All rise.
Kosovo Specialist Chambers is now in session.
Please be seated. Good morning. Welcome. Before we start, I would like to give the photographers the opportunity to make some pictures. Please proceed. Thank you. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-05, the Specialist Prosecutor versus Salih Mustafa.
Thank you. Before asking those present to introduce themselves, I first would like to remind everyone of a few rules that must be observed at all times. Please, before speaking, make sure you activate your microphone, and as you finish, you switch it off. Speak slowly and clearly, because we have interpretation into and from Albanian and Serbian, and in this way the interpreters can do their work properly. And before intervening, kindly wait 5 seconds before, in order to allow the interpreter to finish with the last sentence. I would also like to remind that this hearing is held in open session, unless otherwise requested by the parties and the Victim Council or decided by the panel. And I also would like to remind the parties and the Victims' Council that certain information is subject to protective measures and confidentiality orders. So confidential information shall not be disclosed in open session. And I remind you to give me prior notice should any submission require the disclosure of confidential information so that we can go into private or closed session. And I also remind the parties to adhere to the procedure as foreseen in paragraph 43 and 44 of the decision on the conduct of proceedings with regard to in-court redactions. Now, I would kindly ask the parties to introduce themselves, the Victims' Council and the Registry, and I will want to start with the Specialist Prosecutor Office.
Good morning, Your Honors. Good morning, everyone. Today, the prosecution is represented by Mr. Jack Smith, the Specialist Prosecutor, Filippo De Minicis, Associate Prosecutor, Silvia Dascoli, another associate prosecutor, myself, Cezary Michalczuk, prosecutor in this case, and today with us we have Julie Mann, who is our case manager. Thank you very much.
Thank you, Mr. Prosecutor. Now I turn to the Victims' Council. You have the floor.
Good morning, Your Honours, and good morning, everybody. The Victims' Council's team is today represented by Lisbeth Zechfeld, my co-counsel, by Marie-Pierre Babot, who is my senior legal associate, and Nomza Hachibechiri, who is my junior legal associate, and obviously myself, Annie Poos, as counsel. Thank you.
Thank you. Thank you, Counsel. Now I turn to you, to the defense. You have the floor.
Thank you very much, Your Honor, honorable members of the court. Today, the defense is represented by Mr. Betim Shala, who is joining us via remote. He's my co-counsel. Mr. Fatmir Pillay, who is our investigator, also joining via remote. Today, Mr. Mustafa is present, and myself, I'm the lead counsel. My name is Julius von Bonnet. I thank you very much.
Thank you, Counsel. Now I turn to the registry, please.
Good morning, Your Honours. Present today, myself, the Registrar, Fidel Madonlan, and joining me, the Deputy Registrar, Mr. Stefan Wolfhart.
Thank you.
Thank you.
For the record, my colleagues for Trial Panel 1 are Judge Roland Dekkers, Judge Gilbert Biti, Judge Vladimir Mikula, Reserve Judge, and I am Mappi Veld-Volja, Presiding Judge for Trial Panel 1. Today's hearing is dedicated to the procedure as set out in the rules 124 and 125 of the rules and the opening statements. The opening statements will be heard in 3 sessions, starting this morning till 11, then we will continue at 11:30 till 1, then from 2:30 till 4, and there might be an extra session at 4:30 till 5:30. We shall endeavor to finalize the hearing today. At the end of the 4th session at 5:30 to avoid to put additional burden on the interpreters. We have also scheduled a hearing, of course, for tomorrow, and the 16th. It's our reserve day, and it gives us the possibility, if we don't finish today, to continue tomorrow. The defense has indicated, Mr. Van Bonnet, that it intends to make an opening statement after the conclusion of the presentation of the evidence by the prosecutor and before the presentation of the defense. Yeah, I see you nodding. Okay. Before we begin with the procedure as set out in 124 and 125 of the rules, I will provide a short procedural history of this case. On the 13th of February 2020, the SPO submitted to the pretrial judge for confirmation an indictment against Mr. Mustafa, together with evidential material and in support of the factual allegations, along with a request to arrest and to transfer Mr. Mustafa. On the 12th of June of 2020, the pretrial judge issued a decision on the confirmation on the indictment against Mr. Mustafa. And on that same day, the pretrial judge also granted the request for an arrest warrant and the transfer order for Mr. Mustafa. Then on the 24th, Mr. Mustafa was arrested and transferred to the Specialist Chambers detention facilities in The Hague. And then the 7th of May of this year, this case was transmitted by the pretrial judge to the panel. On the 18th of June, we have taken a decision as a panel to set the commencement of the trial date for today. And then both the pretrial judge and the panel have issued decisions on the participation of victims participating in the proceedings. And up till now, we have admitted 9 victims to participate in this case. In accordance with Rule 124, paragraph 2 of the rules, the trial shall proceed now with the reading of the indictment as confirmed by the pretrial judge by the Specialist Prosecutor Office. You have the floor.
Your Honors, as per your directions and as there was no objection from the defense, we'll just read the charges against Mr. Mustafa and we will not read the indictment in its entirety. In the confirmed indictment, the Specialist Prosecutor charges Mr. Salih Mustafa with count 1, the war crime of arbitrary detention under Article 14, Paragraph 1, Subparagraph C of the law on the Specialist Chambers and the Specialist Prosecutor's Office, the law, committed in a detention compound located in Zlaž, Kosovo, against at least 6 individuals between approximately 1st of April 1999 and 19th of April 1999. Count 2, the war crime of cruel treatment under Article 14, Paragraph 1, Subparagraph Ci of the law, committed in a detention compound located in Zlaž, in Kosovo, against at least 6 individuals between approximately 1st of April 1999 and the 19th of April 1999. Count 3, the war crime of torture under Article 14, Para 1, Subparagraph Ci, committed in a detention compound located in Zlaž, in Kosovo, against at least 6 individuals between approximately the 1st of April 1999 and 19th of April 1999. And count 4, the war crime of murder under Article 14, Paragraph 1, Subparagraph Ci of the law, committed in a detention compound located in Zlaž, in Kosovo, against 1 individual between approximately 19th of April 1999 and around the end of April 1999. In relation to these crimes, there is a well-grounded suspicion that Mr. Mustafa is criminally responsible pursuant to Article 16, Paragraph 1, Subparagraph A of the law for physically committing the crimes under counts 1, 2, 3, committing as a member of a joint criminal enterprise the crimes under counts 1 to 4 and alternatively for count 4, committing as a member of the aforementioned joint criminal enterprise the crime of murder by being aware that such a crime might be perpetrated in carrying out the common purpose of the joint criminal enterprise and by willingly taking that risk. Ordering the crimes under counts 1, 2, 3, instigating the crimes under counts 1, 2, 3, and further and alternatively aiding and abetting the crimes under counts 1 to 4. Further and alternatively to the alleged responsibility pursuant to Article 16, Paragraph 1, Subparagraph A of the law, there is a well-grounded suspicion that Mr. Mustafa is criminally responsible for the crimes under count from 1 to 4 as a superior pursuant to Article 16, Paragraph 1, Subparagraph C of the law. Thank you very much, Your Honors.
Thank you. Mr. Mustafa, please stand up. Mr. Mustafa, I trust that you understand the natures of the charges brought to you. Is that correct?
Po e kuptoj, po s'ka asgjë me të vërtetën.
Mr. Mustafa, during your appearance on the 28th of October of last year, you pleaded not guilty to all counts of the confirmed indictment.
Po,
You have, wait, I will ask you a question. You have now the opportunity to confirm the plea. Do you confirm your initial plea of not guilty to all counts?
po sakt. Sakt, nuk jam fajtor për asnjë nga pikat që mi ngarkon kjo zyre Gestapos.
Thank you, Mr. Mustafa. You may sit.
Thanks.
Mr. Mustafa, let me inform you of some important rights that are afforded to you under the legal framework of this court. You have the right to remain silent, and such silence cannot be a consideration in the determination of your innocence and guilt. You have the right not to be compelled to confess guilt or to testify. You have the right not to incriminate yourself or your immediate family members. You have the right to be represented by a counsel, and I note that Mr. Van Bonnet and his team are representing you. You have the right to have adequate time and facilities for the preparation of your defense and the right to communicate with your counsel. You have the right to be tried within a reasonable time, and you have the right to examine or have examined witnesses against you and to obtain the attendance and examination of witnesses on your behalf. You have the right to make an unsworn statement and to appear as a witness under oath. I also have to inform you that I can order your temporary removal of this courtroom should you adopt disruptive behavior during trial. Now the panel will proceed with hearing the opening statements. We will hear first from the Specialist Prosecutor Office, with the first part delivered by the Specialist Prosecutor Jack Smith. And I was informed that the second part will be by Prosecutor Cesare Mivalchuk. And then we will have the Victims' Counsel doing the opening statement. According to the decision on the conduct of proceedings, we have 3 hours for the opening statements of the Specialist Prosecutor Office and 1.5 hours for the Victims' Counsel. And before I would be giving you the floor, Specialist Prosecutor, could you tell me if you and your colleague will be using the 3 hours allocated to you to do it, or that you will be using less time? It's just for our planning.
Of course, Your Honor. Yes, we will be much shorter than 3 hours. I think it'll be closer to an hour in total.
Okay, thank you for this information. Mr. Smith, you have the floor.
Your Honors, Madam Registrar, Counsel, good morning. As Specialist Prosecutor, I am pleased to have the privilege of addressing you today as we begin the first trial of this court. Today marks a milestone in the life of this institution, the Kosovo Specialist Chambers, and in the work of my office, the Kosovo Specialist Prosecutor's Office. I want to thank each of the countries of the European Union and the contributing states of Norway, Switzerland, and the United States, whose generosity and commitment to the rule of law has made this process possible. I also want to thank all our staff, both current and former, as well as the staff of the other organs of this court, whose dedication has made this day possible. Finally, and most importantly, I am grateful for the essential support of the many individuals who have cooperated with our court in Kosovo and elsewhere, providing us evidence, telling us their stories and those of their loved ones, and above all, placing their trust in this institution to do justice. Without them, my office would not have been able to carry out its mandate to date. It is the synergy of all these efforts that has made it possible to be here today to mark the start of the first trial of this institution. Our court and these proceedings represent different things to different people. First and foremost, ours is a court that was inspired by Kosovar voices and created by acts of the Kosovar people. On August 3rd, 2015, the Kosovo Assembly created this court by passing the law on the Specialist Chambers and Specialist Prosecutor's Office. That very same day, the Assembly also voted to amend the Kosovo Constitution specifically to ratify the existence of the Specialist Chambers and Prosecutor's Office within the legal framework of Kosovo. The Assembly, through its actions, and speaking on behalf of the Kosovo people, gave mandate to these institutions to build on the work of the Special Investigative Task Force and to bring to trial those responsible for grave international and transnational crimes committed in the territory of Kosovo and parts of Albania between January 1st, 1998 and December 31st, 2000. 6 years later, as we commence this first trial, this court speaks proudly to the commitment of the people of Kosovo to the rule of law and to transparent justice. The Kosovo Specialist Chambers and Specialist Prosecutor's Office are institutions of the Kosovo Republic. They apply international law, the law applicable to war crimes and crimes against humanity, as part of the Kosovo legal system, and governed by the Kosovo Constitution. While our court is staffed by judges and lawyers from international countries outside Kosovo, make no mistake, the people of Kosovo have been the real moving force behind the work of my office and the existence of this institution. Without the cooperation and support of many, many Kosovar women and men, we would not be here today. This is a Kosovo court, and it is also a court for and about victims. For many of us, it is the victims and their stories that drive this process and drive us in our work. In the course of this very case, you will hear from victims who have waited 2 decades to be heard. 2 decades to ask for justice for crimes committed against them and against their family members who are no longer with us. If we are to properly serve these victims, there can never be an expiration date on accountability. As we know from conflicts around the world, it is not always possible to do justice for victims in the immediate aftermath of a conflict. In such contexts, like the war in Kosovo, it is terribly important for victims to know that there are people who care and that someday, some way, the crimes that were committed against them will be brought fully to light and the people most responsible for those crimes will face justice. Now, testifying about the brutal acts that were committed against them can itself be traumatic for victims, but if done with proper support, it can also be affirming and even cathartic to be heard, finally. I know the registrar and her staff will do everything within their power to provide the appropriate support to these very brave people so they can tell their stories to you. Playing our role in giving them this opportunity is an honor for myself and for my staff. Well, we will call several victims of the accused in this case. Now, while in other cases before this court, we will bring a mix of victims to the court: Kosovar Albanians, Serbs, Roma, and other ethnicities. In this particular case, however, you will see that the victims of Mr. Mustafa, the accused, were all fellow Kosovar Albanians. I say that again. The victims of Mr. Mustafa were fellow Kosovar Albanians. These people, they were not enemies of the state of Kosovo. They were not spies. They were fellow community members, innocent Kosovar Albanians whose only crime was to be viewed, for one reason or another, as an impediment to the KLA and certain of its leaders, and thus labeled as collaborators. Now, for those who've been opponents of this institution, who have sought to obstruct the work of this court and my office at every turn, this is an inconvenient fact, but it is a fact nonetheless, an unassailable fact. The truth as will be laid before this court in the coming weeks, is that certain KLA leaders, including Mr. Mustafa, used their power to victimize and to brutalize fellow Kosovar Albanians, including individuals whose only crime was to have political views that differed from those of the KLA and its leaders. As you will see in the course of this case, there was no legitimate military objective for their detention, no justification whatsoever for the inhumane conditions under which they were held, or for the manner in which they were brutalized and tortured during their detainment. This brings me to the issue of individual criminal responsibility. The business of a prosecutor is accountability, individual accountability, for crimes that can be proven beyond a reasonable doubt. Criminal responsibility before this court is personal. Article 9 of our law enshrines this principle by giving the Kosovo Specialist Chambers jurisdiction over natural persons. And I want to stress this point because it is of fundamental importance to understand the case you are about to hear against this accused. The SPO's investigations have been focused solely on individuals who, as the evidence will show in this trial, have caused immense suffering, often to the very people they should have been fighting for and whom they were supposed to protect. Mr. Mustafa violated the laws of war and other international laws that exist for the protection of humankind against the abuses of the powerful. The SBO does not levy accusations against the KLA or against the war it fought for its independence. It is neither the job nor the desire of the SPO or myself to do so. Some people, often the same ones who've tried to intimidate witnesses and victims, have tried to create confusion on this matter, to blur this important distinction. They claim that these trials are against Kosovo and its people. Nothing could be further from the truth. To the contrary, that the people of Kosovo chose to create and empower this institution to do the work it is doing now is evidence of its commitment to the rule of law. As this trial will show, and those that follow will show, the charges concern specific persons, named individuals who acted with profound disregard for human life, dignity, and freedom. The charges against the accused in this case concern his individual involvement in detention, mistreatment, and torture of Kosovar people. The trial of this case concerns the personal responsibility of the accused, Mr. Mustafa, whose acts have caused suffering that left indelible wounds in the bodies and the minds of the victims who suffered through it. Your Honors, in the course of this case, you will also hear from the family members of one of the accused victims who did not survive it and who was killed after being brutally and repeatedly tortured. The accused individual and personal responsibility for what was done to that young man, as well as the other crimes charged in this indictment, that is why we are here today. Now, part of the reason this court was created, and certainly why it was located in The Hague, is the often recognized climate of intimidation of witnesses and interference with proceedings that exists in criminal trials against former KLA members. That climate continues to exist, and it will be a backdrop for this trial. As witnesses come before this chamber to testify and tell you their stories, witnesses who live in this climate every day, your honors will be asked to consider if and how their testimony is affected by the pressures that many of these witnesses face. The pressures they feel not to come forward, not to tell the truth about what they saw, what they experienced, or what happened to them. To date, this climate of intimidation, the countering of which remains the top priority of my office, has fallen well short of achieving its objectives. We're here today because it has not stopped the people you will hear from, the witnesses in this case, from coming forward, from telling their stories. Their desire for justice and reconciliation has proven stronger than that of a few individuals who, for personal and other abject reasons, have been trying to hinder the path of accountability and deny victims their right to justice. We must be vigilant in appropriately supporting these witnesses, given what we know many of them have gone through to take the witness stand in this courtroom. This institution, the Kosovo Specialist Chambers, represents many things to many people. To a large number of people in Kosovo, this court represents a last chance for justice for a vast number of victims. Unfortunately, to others, this court is viewed as something to be distrusted and therefore attacked. Opponents of this institution will often describe the conflict in which the KLA engaged as a clean war. The premise being that if the cause was just, it was simply not possible that anyone in the KLA could have acted illegally in the service of that cause. These same opponents often cite crimes committed by their adversaries as a complete justification for crimes committed by those on their side of the conflict. The opponents of this court use phrases like clean war in a cynical attempt to manipulate the justifiable national pride of Kosovars against an institution that is evidence of the country's commitment to the rule of law and which will do justice for many, including a great number of citizens of Kosovo who suffered as a result of the crimes alleged in the SPO's indictment. As a prosecutor, it is beyond my remit to argue to you or decide what wars were just and what wars were not. But I can say with conviction that war crimes on one side do not justify war crimes on the other side. Perhaps just as importantly, I know that truth never damages a cause that is just. To those who do not have confidence in the fairness and the transparency of these proceedings, I say watch this trial and watch those that follow. Watch how this court functions and then judge. The standards of due process have been and will no doubt continue to be followed at this institution to the highest degree. For this institution to truly fulfill its mandate, each and every accused tried before it, beginning with Mr. Mustafa, must receive a fair trial according to the highest standards of international justice. I have no doubt that will be the case for Mr. Mustafa and for each accused tried thereafter. Your Honors, in the end, the work of this court represents opportunity. Opportunity for Kosovo to put the issues of this war behind it, once and for all. An opportunity for victims to have their voices heard, and heard in a setting where they can speak the truth without fear of retribution or intimidation. It is also an opportunity for the accused to have the allegations against him publicly aired and vigorously tested by able counsel like Mr. Von Bonnet. If we cannot sustain our burden of proof in these cases that we bring, it will be an opportunity to clear their names once and for all. I also firmly and deeply believe this court represents an opportunity to show that international criminal justice can work, that trials do not need to take years to complete, that justice can be thorough, reasoned, transparent, efficient, and fair, that we can take the best from past tribunals, that we can apply rigorous standards for lessons learned, and achieve a functionality and a practicality for this institution that has frankly eluded other criminal justice institutions in the past. It's an opportunity to prove that creating and supporting courts like this makes sense because they can function effectively, they can contribute to justice and to a public airing and understanding of the facts, and hopefully, ultimately, to some healing. This court is a contribution to the larger project of international criminal justice, and each case that is litigated fairly and justly before it adds to the whole of that contribution. While this court represents different things to different people, for all, it should and must represent an opportunity to seek justice. Thank you for the opportunity to address you this morning. I will now turn the floor over to Prosecutor Michalczuk, who will illustrate to your honors and to the public in further detail the case we are about to present and how the SPO will prove that the accused is personally responsible for the crimes with which he is charged. Thank you very much.
Thank you, Mr. Specialist Prosecutor. Mr. Michalczuk, you have the floor.
Your Honors, the case that the prosecution will present to you is simple and straightforward. In April of 1999, during the war in Kosovo, the accused, Mr. Salih Mustafa, along with his associates and subordinates, unlawfully detained and severely mistreated a number of local Kosovo Albanians. They were civilians. One of them was murdered. All of the victims in this case, and I have to again emphasize that fact, were Kosovo Albanians. As I will describe in more detail in a bit later in this opening, these unlawfully detained victims were held in deplorable conditions, unfit for humans, and they were repeatedly mistreated, abused, threatened, and severely beaten by their captors, including the accused. The evidence will show that these crimes all happened in the small and remote village called Zlaž in Serbian, in the mountainous region of Goljak in Serbian. The place was not far from Pristina, and the crimes were committed within a period of about 3 weeks, between approximately the 1st and 19th of April 1999. In the village of Zlaž, there was a rough makeshift detention center where the prisoners were held. We will refer to this place as the Zlaž detention compound. And it was run by members of the Kosovo Liberation Army, in particular by the group called BIA, B-I-A, which was commanded by the accused. I will tell you more about the BIA unit and its purpose a bit later in this opening statement. Why was a KLA unit illegally arresting, detaining, and abusing Kosovo Albanians during the war? The evidence will show that the men who were brought and illegally detained in the Zlaž detention compound were accused, among other things, of being so-called collaborators in the war. To be accused of being a so-called collaborator during the war was grave and often deadly. But let's be very clear. These men, these prisoners, were not collaborators in the sense of aiding the enemy in their military actions. No, not by any means. None of the men held in Zlaž had done that, and nobody in this trial, nobody, will claim that they did. No. Instead, the collaboration label was one that was broadly used and really misused for persons who socialized with Serbs, did business with them, associated with them, or is simply perceived as not sufficiently supporting the KLA or as displaying the wrong political affiliations. the mere suspicion of any of these activities or attitude could land you in Slash. And once you ended up there, the conditions and treatment were brutal. Your Honors will hear from the men who were grabbed, arrested, brought to Slash, and imprisoned there by members of the Kosovo Liberation Army. They will sit in that witness chair and will tell you about the conditions of their detentions, the daily abuse, the beatings and interrogations. You will hear about the injuries they suffered, about how their bodies were broken and their spirits traumatized. You will also hear evidence about one victim who did not survive and was murdered by his captors. The accused in this case, Mr. Salih Mustafa, was in charge of the Slash detention compound and participated himself in the abuse and the beatings. Your Honors, in this opening, I will first tell you a bit about the accused and his position within the Kosovo Liberation Army, with a special emphasis on the BIA unit that he was commanding during the time relevant to this indictment. I will then move to a description of the location where the crimes charged in the indictment took place. Following that, I will briefly discuss the armed conflict in Kosovo, which was the context in which the crimes charged in the indictment were committed by the accused and his subordinates. After outlining the armed conflict, I will provide Your Honors and the public who is following this opening with a summary of crimes that took place in the Slash detention compound, with a special emphasis on the plight of the victims and the responsibility of the accused in this case. Salih Mustafa, a Kosovo Albanian, born on the 1st of January 1972 in Pristina, joined the Kosovo Liberation Army in early September 1997. Prior to that, he had been a member of the National Movement for the Liberation of Kosovo. From the very onset and until the end of the conflict in Kosovo in June 1999, he was the leader and commander of the Kosovo Liberation Army intelligence gathering and support unit called BIA. The BIA unit was organized into subunits, and around March 1999, it numbered approximately 500 to 600 members. The accused was the unit's overall commander. The BIA unit carried out tasks such as reconnaissance, sabotage actions against enemy installations and units, as well as the provision of medical supplies. One of its main tasks was intelligence gathering, an activity led by the accused himself. The evidence will further show that the BIA unit was responsible for the Slash detention compound. In March and April 1999, they were responsible for that place, and the accused was in charge of that compound, and both was present for and was participant in detentions and beatings that were occurring there. The BIA unit covered the urban areas of Pristina, Fuš, Kosovo, in Serbian Kosovo Polje, and Obilić, with the presence also in the villages of Butovc, Rimanište, and Slash, within the Golak region. Madam Court Officer, could I kindly ask you to show slide number 1, please? Your Honors, you can see on that slide, slide number 1, the approximate area of BIA operations. This area is encircled with this blue, dark blue circle. I believe this slide can also be of assistance with regard to the general geographical context of the case. Could we now please show slide number 2, which is the close-up of the previous slide. This slide shows the approximate area of BIA operation in more detail. We can see the city of Pristina and the areas around it where BIA unit operated in 1999 in time relevant for this indictment. The symbol of the BIA unit was a hawk, in Albanian skifteri. The code name of the BIA unit was in fact skifteri, which the accused explained was used to identify the unit in radio communications. If we could now show slide number 3, please. BIA members did not all wear the same uniforms. However, some of them wore black uniforms with a patch featuring a hawk and the word Skifterat around it. And you can see that emblem featuring on this slide. Witness W01679 will testify that those who arrested him wore, and I quote, an insignia with a hawk and the word Skifterat written around it. And that description corresponds to the emblem which is depicted on this slide, Your Honors. In 1999, including in the period of the indictment, the accused, as he himself admitted, mostly wore a military uniform and used a black or red beret. The wearing of such a beret was something unique to the accused and was not part of the BIA uniform. Your Honors will learn in the course of this case that at least one witness detained and mistreated in Slash saw the accused in a red beret. When the accused was arrested, his wallet contained a photograph of himself in Kosovo Liberation Army uniform wearing such a red beret, and his phone and some USB sticks on his person also contained photographs of him during the war, again with the red beret. Here are a few of those photographs, and if you could show the next slide, please. Slide number 4. Could we move to slide number 5? Could we move now to slide number 6, please? Slide number 7. Slide number 8, please. Slide number 9. Let's move on to slide number 10. And finally, slide number 11. The accused was formally appointed to the position of the BIA unit commander in May 1999 by Mr. Rustem Mustafa, commander of the LAP operational zone of the Kosovo Liberation Army. The BIA unit was directly subordinated to the LAP operational zone command and not to any brigade of the Kosovo Liberation Army operating in that region. In his voluntary interview with the Specialist Prosecutor's Office, the accused admitted that he had ultimate authority over BIA soldiers, a circumstance that was confirmed by other KLA members who will testify in this trial, as well as by the interactions between the accused and his subordinates witnessed by the victims in this case. A certain number of BIA members were involved with the accused in the detention, mistreatment, and murder that took place in April 1999 at the Slash detention compound. Your Honors will hear the names of these subordinates from the victims. They heard the names and nicknames of their captors and torturers during their detention in Slash. Apart from BIA, a few other KLA units operated also in that same area. One of them was 153rd Brigade, named Khizri Tala, which had the village of Slash as the entire Golak region within its area of responsibility. That brigade was headquartered approximately 15 to 20 minutes on foot from the Slash detention compound. The evidence will show that this brigade operated separately from the BIA unit and had no role running the detention compound. Your Honors, from July, August 1999 until at least the end of April 1999, the BIA unit had in Slash what the accused described as a safe house, which was located within the Slash detention compound. Slash is a small isolated village located approximately 10 kilometers east of Pristina in the mountainous region of Golak. Could I ask Madam Court Officer to show us slide number 12? This slide, and also the following slide, are aerial photographs of the detention compound in Slash taken in 2006 by the United Nations mission in Kosovo, UNMIK. In this slide, Your Honors can see a small cluster of just a handful of buildings that formed the compound. The evidence will show that the victims were held in a small group of connected buildings within the compound, and that the accused spent time in the upstairs part of one of these buildings and interrogated some of the detainees there. All of the crimes alleged in this case occurred within this particular compound depicted on that slide. Could we now display slide number 13, please? So if we now zoom out a little bit from the compound, Your Honors, the compound that we have just seen on the previous slide, we can see how isolated this compound is. There is nothing around it. To one side of this small group of buildings are some woods, and to the other, a road. Given the small size of the compound and its isolation, it should be clear that the detainees who were seized and brought here to be held were cut off from anywhere, and that persons present at this compound in April 1999 surely would have known what was happening there. Now let's talk for a moment about the armed conflict that was happening at the time the alleged crimes were committed in April 1999, Your Honors. During this time and throughout the whole indictment period, a non-international armed conflict existed between the Kosovo Liberation Army and forces of the Federal Republic of Yugoslavia and the Republic of Serbia, including units of the Yugoslav Army, police, and other units of the Ministry of Internal Affairs, as well as other groups fighting on behalf of Yugoslavia and Serbia. There should be no dispute about this fact. The conflict was of high intensity, with a series of offensives of the Yugoslav and Serbian forces in February and March 1999, and large-scale operations launched throughout Kosovo, including against the Kosovo Liberation Army forces stationed in Golak region in April 1999. The conflict had a protracted character dating back to 1998, well before the crimes alleged in the indictment, and continuing throughout 1999, well past the dates of those crimes. The level of organization of the warring parties was sufficient to qualify it as an armed conflict under international law. Yugoslav and Serbian forces were a proper modern state army, well organized and structured with a unified and central command. And the Kosovo Liberation Army, already in 1999, was an organized armed force under a responsible command, had control over parts of the territory of Kosovo, and had the ability to carry out sustained and concerted military operations. It was issuing internal regulations, orders, and public communiques, had a proper reporting and communication system between its general staff and the subordinate combat units, brigades, battalions, companies, and squads. It was divided into operational zones, with each having its commander. It had weapons supplies, a recruitment system, training centers, and a system of ensuring military discipline. Its soldiers had uniforms and unified army markings. All these elements are indicia of a sufficiently organized party to the armed conflict, which the Kosovo Liberation Army undeniably was at the time relevant for this case. There are several judgments from the International Criminal Tribunal for the former Yugoslavia, ICTY, and Kosovo courts that have made findings concerning the existence of a non-international armed conflict in Kosovo in April 1999, including specifically the Djordjevic and Milutinovic cases at the ICTY, and your honors have taken judicial notice of relevant findings from those cases. No judicial body has ever denied the existence of that armed conflict, and nobody who was in Kosovo at that time would seriously contest that such conflict existed. As it will become clear in the course of the trial, the crimes charged in this case took place in the context of and were associated with this ongoing armed conflict between the Kosovo Liberation Army and the forces of the Federal Republic of Yugoslavia and Serbia. These crimes were committed by active duty soldiers in the Slash detention compound used by the BIA unit as a base. The accused himself, the commander of the BIA unit, was engaged during this time period in activities related to the armed conflict. Notably, during interrogations, the accused and his subordinates levied accusations against their victims about being spies and collaborators. While vague, unsubstantiated, and in fact unfounded, these allegations demonstrate the link, together with other circumstances, between the ongoing armed conflict and the crimes committed by the accused and his subordinates. Now allow me, your honors, to turn back to the buildings within the Slash detention compound where the crimes charged in the indictment allegedly took place. It was a two-story building. As you have seen from the aerial photographs of the compound, the building was part of a small handful of buildings, isolated from other structures. Today, this compound is no longer standing, and only one small building remains there. Let me show you a few additional images of that compound taken by the United Nations mission in Kosovo in April 2006. I hope it will assist your honors to better understand the composition and layout of that place. I will start again with the 2006 aerial photograph that I already displayed a few minutes ago. And could I kindly ask Madam Court Officer to show us the next slide, slide number 14. The encircled building is the one where, as the prosecution alleges, crimes charged in this indictment took place. Could we now move on to slide number 15, please? This slide, Your Honors, depicts 3 buildings of the Slash detention compound where, in the prosecution's submissions, in April 1999, a number of Kosovo Albanian detainees were unlawfully held and mistreated. The blue arrow indicates the rooms in the upper floor used by the BIA members, as well as the accused when they stayed in Slash. The yellow arrow points to the lower part of the building where the victims were detained. Could we please display the next slide, slide number 16. This slide presents the same buildings from a slightly different angle. The building presented on the right-hand side of this photograph is the one which is of our interest in this case. The blue arrow is pointing at that building. We saw it also at the previous slide, and we'll see it again in a moment. Could I kindly ask Madam Court Officer to show us the next slide, slide number 17. Thank you very much. This slide depicts the main building where the alleged mistreatment of some of the victims took place. They were kept in a basement or shed in the lower part of the building, left from the door with a staircase indicated by yellow arrow. And they were taken by external stairs to a location upstairs where they were interrogated and beaten. And it's marked, this place is marked with the blue arrow. The accused himself also provided a detailed description of that building. Your Honors will see the same building depicted also in photos presented by the defense, one of them being the photo on the next slide, slide number 18. And if I could kindly ask to show this one, this is the slide I'm talking about. On that slide, the building is on the left-hand side of the photo. The blue and yellow arrows indicate respectively the place occupied by BIA, where interrogations and mistreatment of victims took place, and the place where the victims were held, which is the yellow arrow. The adjacent smaller building, a wooden shed with triangular roof covered with red tiles, the one next to the building we're talking about, is the only building that remains on that site today. Former members of the Kosovo Liberation Army Brigade 153, stationed in Slash, will testify that in 1999, this compound was occupied exclusively by the BIA unit under the command of the accused. The accused himself has admitted that he was often in Slash in March and April 1999. The prosecution will present evidence from several witnesses who will also place the accused in the Slash detention compound at different times critical to this case. We can now close the presentation, the PowerPoint presentation, please. Thank you. I will now turn your honors to the evidence, to what the evidence will show concerning the defense put forth by the accused in this case. The defense has in fact noticed two defenses in this case. The first it has set forth is an alibi defense. When your honors listen to the evidence about the alibi, you will want to ask yourselves why the accused now is trying to claim that he was not at the Slash detention compound at certain times. We say it is because the evidence will show that in fact the crimes that we have alleged occurred there, and that now the accused is trying to get as far away from those crimes as he can. Your Honors will also want to scrutinize the evidence by the prosecution and by the defense to assess whether there really is an alibi. We submit that both prosecution as well as certain defense evidence will clearly place the accused in Slash at specific points in time in the first 20 days of April 1999, relevant to this case. Moreover, the evidence will show that when he was not at Slash, he was in locations that were easily reached in a matter of hours by car or on foot. At the end of the day, none of the alibi evidence of the defense refutes in any way the allegations set forth in the indictment. The proposed alibi does not provide either a factual or legal shield from responsibility. In addition to putting forward this so-called alibi defense, the defense also alleges that the crimes at Slash simply did not occur at all. No arrests, no detainees, nobody held, no interrogations, no beatings, no mistreatment, no abuse. None of it happened. In this regard, the Chamber will want to consider the evidence from all the witnesses, statements of the accused, as well as the accused's conduct during the investigation of these crimes. We submit that the evidence will leave no doubt whatsoever that these crimes occurred and that the accused was responsible for them. Turning now, Your Honors, to the crimes alleged and the victims who were unlawfully brought to the Slash detention compound, illegally detained there in appalling conditions, interrogated and subjected to various sorts of brutal mistreatment virtually on a daily basis. These victims were all local Kosovo-Albanian civilians, and none was taking an active part in the hostilities at the time that they were arrested, beaten, and killed. During their interrogations, the detainees were accused of being spies, Serbian collaborators, or thieves. The reality is that none of these men posed any military threat to the Kosovo Liberation Army. Some were trying to get by during the conflict by selling goods at the local markets. Others were civilians whose only fault was to belong to another party, the Democratic League of Kosovo, LDK, that was perceived by some members of the Kosovo Liberation Army as a political opponent. Your Honors will hear evidence about how different victims in this case were arrested and brought to the Slash detention compound, including from some of the victims themselves. They will tell you about the layout of the compound, how they were held, who else they recognized there. You will hear that aside from baseless accusations made during interrogations, they were not told why they had been arrested or detained. No arrest or release documents were provided to them. You will hear how the victims were made to sleep on the floor in an animal barn, given insufficient food and water, and kept in extremely unsanitary conditions. No medical care was offered to mend the wounds inflicted by the accused and his subordinates during the frequent interrogation and beating sessions. The victims will tell you about those interrogations and beatings, who participated in them, and the instruments used to assault them. You will learn what was asked of the victims and what they were accused of. You will hear about the threats that were made and about the conduct that rose to the level of torture. You will also hear specifically about the role of the accused in certain of the interrogations and beatings, that he oversaw them, directed them, and participated in them. The victims will testify that they could hear when others were being beaten, and they will tell you about the severe physical and psychological injuries they suffered, some of which continue to affect the victims to this day. The evidence will show that one victim was singled out for particularly harsh abuse and suffered particularly severe injuries. When the victims were released from the Slash detention compound in April 1999, on the 19th of April to be precise, because of an advancing Serb offensive, this prisoner and one another were not allowed to leave. Neither one was ever seen alive again. Sometime later, after a painful and intense search by the family, the body of the severely mistreated victim was found in a shallow grave a very short distance away from the Slash detention compound, along with a second body. Based on these facts, the indictment in this case charges the accused with the war crimes of illegal detention, cruel treatment, and torture, and murder of the severely beaten victim who was not permitted to leave the compound and whose body was found sometime later. The accused is responsible for the crimes committed at the Slash detention compound through his personal participation in them in concert with his subordinates. The accused ran the compound, and by his own admission, he had ultimate authority over the BIA members stationed there. He personally participated in interrogations and beatings. He had the authority to prevent their mistreatment and to release them, but he did not do that until he was forced to evacuate the compound because of the advancing Yugoslav and Serb forces. In addition to directing, overseeing, and participating in the crimes alleged, the accused had ample knowledge of them. He slept in the same house where the prisoners were kept. Screams of pain during interrogations and beatings, which generally took place on the upper floor, where the accused normally stayed, were so loud that they could be heard from the other prisoners one floor below. The detainees' bodies displayed obvious signs of the mistreatment that they had received. This is a preview of the evidence that will be offered in this case. As I said at the beginning of my remarks, this case is straightforward and simple. The crimes were committed by the accused and his subordinates during a several-week period in April 1999 in a contained, small, and isolated compound in Slash. The accused was there, he was in charge, and he is ultimately responsible for the crimes. For these reasons, at the end of the case, we will return before your honors to ask that you find the accused guilty of the crimes charged in this indictment. Thank you very much.
Thank you, Mr. Prosecutor. Thank you, Mr. Prosecutor. I look now at the time. It's 11:15. I propose also to the Victims' Council that we take a break now of half an hour till a 11:15, and then we resume, and then can you start with your opening statement? Yeah? Okay. Now, the hearing is adjourned. See you at 11:15.
All rise.
Please be seated. Okay. Welcome back. Yes, before we go to the opening statement of the Victims' Council, there's another matter we should address. Mr. Van Bonnet, I was informed that your client does not want to attend the hearing any further today. Yeah? And I note there's a procedure for that, and I see you nodding. That's Rule 68, Paragraph 4 of the rules. And provided that all the conditions in Paragraph 4 are met, the accused can refuse to appear. And do you want to make any submissions in this regard?
Your Honor, thank you very much, members of the court. Indeed, it is what the accused clarified to me, that he does not want to continue for this session to attend the session further. I do not have a particular submission about that. It is just what it is. I assume that he will just discontinue it for this session, and I expect him to be there on Monday again. So that is all there is to it. I will be, of course, remain present, as I'm always here. So I think that unless no, it is clear that he just told me that he does not want to continue to be present at the hearing of today.
Okay. I'm going to ask you some questions in this regard, and then, even if it's not provided for by the rules, I will give the Specialist Prosecutor Office and the Victims' Council the floor to make any observations in this regard if they feel the need to. But before I do that, I want to go through some conditions set out in Paragraph 4. There has, of course, been an initial appearance, and Mr. Mustafa is aware of the fact that his presence is required in principle. He is not here anymore, but in principle that he is required to be here. And a very important part is that he has waived his right to be present here unequivocally and voluntarily. I mean, you can...
Yes, I can say that he waived his right to be here unequivocally. Okay. That is clear for today's court session. It stipulates the right to be tried. I'm not sure about the trial in itself, the wording of the word trial in this sense, but I mean for the hearing of today.
I opened the trial this morning by default by being here, so it's the trial. Yeah. I would say there's no discussion about that. Another point for me, what is important, you will be present, you confirmed that.
Absolutely.
And you will represent his interests.
Absolutely.
During this hearing. Okay. Okay, then it's up to the panel to see if they think it's necessary to have him here for this hearing.
Yes, Your Honor. Thank you very much.
Okay. I now give the floor to the Specialist Prosecutor Office.
Yes, thank you, Your Honor. The prosecution's strong preference is for the accused to be here with us during this hearing. However, in this regard, we defer the decision to the court as provided by Rule 64, paragraph 4. What we want to have is a clear record, especially of the fact that the accused, pursuant to Rule 64, paragraph 4.c, has voluntarily and unequivocally waived or forfeited his right to be tried in his presence. So we've got to have it clear on the record to have it for further proceedings. If something comes up later, for example, in appeals proceedings later on, that the accused was deprived of his right to be present, we have to have it on the record. That he did it voluntarily, he did it consciously, and he waived his right knowing that these proceedings will continue in his absence, and that his interest will be duly represented by his counsel.
Thank you, Mr. Prosecutor. Those questions have been asked to the Specialist Counsel, and they have been answered in the affirmative. So I think that for now, that is on record.
And excuse me, Your Honor, I take it that the Special Prosecutor meant, my learned counsel meant Rule 68, not 64.
I overheard that,
Yeah.
but we are
Yes.
talking about Rule 68.
Rule 68, paragraph 4.
Very well, that's clear.
Thank you. Sorry.
Victims Counsel, do you have any submissions in this regard?
Yes, I do, Your Honours. First of all, with regard to Rule 68, the clear principle set out in Rule 68 is the presence of the accused. When you look at paragraph 1, he shall be tried in his or her presence. We do perceive this as a clear disregard and disrespect for victims to leave just before the opening statement. But that's a non-legal matter. But this is the principle, and then comes, and the whole spirit of this rule is written, or the whole purpose is to secure the presence of the accused. When an accused is at liberty, detention follows if you don't attend trial. You need to show good cause to be exempt. If the accused is not at liberty, and this is where paragraph 4 comes in, the conditions, the subconditions in subparagraphs A to E are cumulative in my reading, because the end, at the end of subparagraph D, clearly indicates that all of those conditions need to be met. So ultimately, it will be in your discretion, the panel is of the opinion, that the presence of the accused is not necessary for the specific hearing to take this decision, whether you order the accused to be present or not. What I would request you to consider in that context is, will we see this game every day? Every trial hearing the same thing? That the accused chooses whether he's there, whether he's not there, so that, for example, those witnesses appearing for whom this will be a very traumatizing event do not even have the possibility to prepare for whether they will face the accused sitting here, which is a very different matter to a person not being there. And those settings within the courtroom are of key importance. And of course, then, just to finish off on these observations, of course, the presence or a trial in the presence of the accused is clearly all linked to fairness of the proceedings. And a fair trial, of course, is a right of the accused, but it goes further. Fairness of the proceedings is also relevant for the perceptions to the outside world, and ultimately to the legitimacy of this court, of how this court is perceived. And therefore, I think it's important that this court emphasizes at the beginning, when you, Your Honours, are going to shape the practice not just of this trial, but of continuous future proceedings, that the default position should be the presence of the accused, so that this doesn't turn into a court that de facto tries accused in absentia. Thank you.
Thank you very much. Do we need a second round? So I look at a specialist counsel.
Yes, I just want to address two issues that my learned counsel just addressed. First of all, Your Honor, it is a common practice that with all the hearings that we had until now, the accused is present or not present, and he waives it by simply indicating that on a particular document that is filed each time before the proceedings. So I do not think that the cumulative issues that my learned counsel is addressing is of that nature that these are in fact cumulative. I do not think that there is a decision to make on it, and as I say, he is being represented by counsel who is representing his interest in that perspective, and that is further up to the accused how to go about that. Other than that, I can understand, obviously, that it's maybe the feelings that the Victims' Council has regarding issues of victims or not. I cannot simply say that this is going to be a standard or not. It is just for this day what it is, and I cannot give anything for future appearances. Once again, each time there will be a document to be filed, whether the accused will be present or not present, or by a video link present or not present. So those are the things that I wanted to just address to that part of my counsel, the learned counsel of the victims.
Okay. For my information,
Yes.
just to understand,
Sure.
to make a good summary of what you just said,
Yes.
is your explanation of rule of paragraph 4 that it's not cumulative?
It is indeed. Yes. Present is not required.
No, again, no, because maybe we are not understanding each other. That cumulative in the sense that he has to have made his initial appearance.
Obviously.
And
yes.
that
And
happens.
Which is what he has.
Duly notified that he should be here,
Yes.
that he is, that he has waived his right, yeah,
Correct.
that you will be here,
Yes.
and then the last, that in the end it's the panel that think it's necessary, and that last requirement, do you say that it's not cumulative?
No, I understood my learned counsel different, that it was the entire Rule 68 that she was citing as being cumulative.
Yes, and that is my question to you.
I think it is Rule 68(4) that is cumulative.
I don't
The parts of
understand you.
Rule 68(4), those issues are the cumulative issues.
A
Not
till E.
until, yes, so not from 1 until 6.
Okay, but now you
That
have
is what I-
answered my question
that
that
is what-
the
what I
conditions
was
set out in paragraph 4, A to E, you do regard them as cumulative.
That's right.
Okay,
Yes.
that's then clear for me. We were now in the second round, so I go back here to the SPO.
Your Honors, we've got nothing to add. Thank you.
Victims' Counsel.
No, thank you. Nothing to add either.
Thank you. I will now confer with my colleagues, but I will, however, do that not here. We will go back. We will try not to make you wait too long, but I think it's better to not do that in the courtroom. Yeah? Okay. I adjourn just for.
All right. All rise.
Please be seated. I will now give an oral order under Rule 68, paragraph 4 of the rules. I note that in the present case there has been an initial appearance. The accused has been duly notified that he is required to be present. He has unequivocally and voluntarily waived his right to be present. His counsel is present and will represent his interest during this hearing. And furthermore, in the specific circumstances of the case, the panel is of the opinion that however the presence of the accused is required, it is not necessary to be here today. However, this refusal to appear, Mr. Van Bonnet, only concerns the remainder of today's hearing held today. The panel retains discretion in the future hearings to compel the accused to be present, even when he has waived his right to do so. This concludes my order. Madam Court Officer, you can inform security that they can proceed with making the necessary arrangements for the accused to go to the detention center. And Mr. Van Bonnet, there's one last issue I would like to discuss with you or share with you that the panel would appreciate if you could inform your client that we will not allow Mr. Mustafa at future hearings the use of disrespectful language with regard to any party or participant to these proceedings, such as the language used by your client when referring to the SPO. Yeah?
I will certainly do that, Your Honor.
Thank you. Good. Now, I have a look at the clock. It's 12:15. I think now the moment is there, Victims' Counsel, for you, Ms. Bues, to take the floor for your opening statement. Please.
Your Honours, Specialist Prosecutor's Office, Defence, and everyone else who may be following these proceedings today. Of course, first of all, we note the absence of the accused, so I've not said Mr. Mustafa or not addressed him explicitly, which I intended to do because it is indeed very important that some form of engagement with each other's position is being made. We do see this as a note of disrespect, this absence, but nevertheless, it is important to set out today what is important from the victim's perspective. And I must say, it is a very special moment for all those victims participating in these proceedings. It is a moment they have all been waiting for, and they all hope to finally see some justice done. It is 22 years after the victims to whom I provide a voice and who we all stand here to represent experienced events that would change their lives. I met with and spoke to all of them, all those victims participating, and all meetings were loaded with grief and trauma. None of the wounds inflicted in 1999 healed. Physically, some might have. Others turned into scars, lumps in their heads, bends in their limbs, or impaired a person's eyesight. None of the invisible scars, though, those inflicted on the soul, ever had any chance of healing. If anything, these injuries have overshadowed so many other aspects of life, put a fog over all those other moments that should have brought joy and happiness in a person's life. And personally, I was struck by how present the trauma is, how stark the fear and intimidation for all those victims admitted to participate here in these proceedings. Your Honours, we have heard the prosecution's case, and the Office of the Specialist Prosecutor has set out the crimes committed in Slush. And we will neither repeat the indictment nor the prosecutor's case. We will address instead the following issues. Firstly, we will focus on what these trial proceedings mean for the victims we represent here, to allow you all a better understanding of their interests, of their views and their concerns. We then turn to the need for justice, for truth, and for reparations. And lastly, we will end our opening statement with the voices of the participating victims, their wishes and visions for the future. And let us hope, this is my sincere hope, that we can contribute to those wishes and work towards making them a reality. So with that, the meaning of the proceeding for victims. And let me say, the disillusionment among victims is great. They have been waiting for so long, and they are tired of unfulfilled promises. Victims who suffered from the hands of KLA fighters have been failed, as they have not had any chance to seek effective redress for their suffering, not in any domestic, hybrid, or international courts. And this failure, of course, is the backdrop of why it was necessary to set up this court. This is also why the work of this court will be the last chance to do so, to provide redress and to provide justice. This then leads me to the appeal to the panel that whichever decision you must take within these proceedings, the aim, the guiding aim should always be to provide justice now. No decision should be taken based on considerations of procedural economy, for example, or pragmatism. Instead, with any decision this panel must take throughout these proceedings, the test should be which decision will best ensure that justice is being served now. For the victims participating in these proceedings, it is important to be able to achieve some closure and feel that their waiting is over. But there is another dimension which adds such meaning to this trial. It is the silence surrounding crimes committed by KLA fighters. A veil of silence has been covering some of the crimes committed during the war in Kosovo. The victims participating here have been silent and silenced for all these years. They are living in a country where in many places the KLA are celebrated as heroes, where the pressure is tremendously high not to ask any questions that would stain the shining image of heroes. This trial may be a chance to slowly start a conversation, to allow dialogue in Kosovo, to understand fully what happened during the war. This is a chance to pierce this veil of silence surrounding these crimes. It is an important chance also for future generations in Kosovo and beyond to get a fuller picture of their history, to learn and to understand. To this day, an imbalanced war narrative determines perceptions in Kosovo. This trial is an important opportunity to address this imbalance. And because this is a critical aspect of this trial, let me explain in more detail why the current narrative of the war in Kosovo, 1998 to 1999, is imbalanced. 11,609 out of 13,535 victims of this war were civilians. A part of those were direct victims of KLA fighters. This group of victims, however, has systematically been marginalized. At many levels, they were not and are not treated as equals with those celebrated as martyrs, invalids, veterans, and the KLA members. It leaves a very important slice of history untold and not acknowledged. The victims' voices, as I've said before, were silent out of fear of retaliation and further marginalization. They have not been victimized only once when the crimes occurred during the war, but they have suffered after the war by being left completely alone, directly or indirectly intimidated and silenced for decades. Intimidation of those who raised their voice against Albanian perpetrators have been a problem in proceedings before the International Criminal Tribunal for the former Yugoslavia, in hybrid courts, as well as ULEX proceedings. In cases against Serb perpetrators, intimidation has not been the case. In contrast, individuals stepped forward voluntarily and shared their stories in front of the public. Victims of the Serbian regime had a platform to share their stories openly and receive sympathy from the rest of the population. Those victims of KLA fighters to this day have to live in fear and face social apathy towards them. And it takes a lot of courage for victims to participate here and witnesses to testify in these proceedings and to help correcting the incomplete picture of the war. The imbalance I have spoken about and am addressing here is also reflected in domestic legislation. An illustrative example is the law on the status and the rights of the martyrs, invalids, veterans, members of the KLA, civilian victims of war and their families. This law, which is also largely known as the law on war reparations, provides access to reparations for specific categories of people. According to this law, a civilian victim of war is a person who has died or was wounded by the enemy forces between February 1998 and June 1999. A civilian hostage of war is a civilian person, again, who during the war has been arrested and imprisoned in enemy camps for at least 3 days. And this use of the term enemy that runs through this law, which considers this same law, which considers KLA members as martyrs, excludes any victims of crimes committed by KLA fighters. The victims of KLA fighters are therefore denied any acknowledgement in this law or the modest pension that this law provides. Basically, the situation can be summarized as follows. If one is a victim of the Serbian regime, they are encouraged to come forth with their stories, encouraged to seek justice, encouraged to get compensation. If one is a victim detained arbitrarily, tortured, murdered by the hands of KLA fighters, their suffering is ignored. They are being gaslighted, accused of harming the reputation of the KLA or of not being patriotic. And the commemorative landscape is no different when it comes to memorializing victims of the war in Kosovo. It takes a short stroll in most of the main squares in Kosovo to see statues of KLA members, but also to notice that there are only a handful of them memorializing civilian victims, and there are none memorializing victims of events where KLA soldiers were the perpetrators. So, the situation is so much more nuanced than the binary narrative of the war that has been imposed so far. In the current narrative, there's this glorious war, an affair between two fighting groups, that of Serbian forces and the KLA. Yet, this is only one part of the story. And this trial, therefore, is this unique opportunity to help shed light on the hidden stories of those victims who suffered from the hands of KLA fighters. And this function of the trial is linked to the victim's right to truth, a right I will come back to later in this statement. At this point, I want to recall a judgment that this panel is well aware of, the judgment of the European Court of Human Rights in El Masri, because there the right of truth was found to be so important, not for the victims, but also for other victims in similar cases and the general public, who have the right to know what happened. The imbalanced narrative to date therefore matters hugely and is not only a concern for the victims participating here, but important for the public. Finding acknowledgement of their suffering and receiving reparations in these proceedings are not solely important for victims here we are representing. It will also be important as a signal and as encouragement to others who share a similar story, to come forward with their stories. Let them know that they are not alone in these battles. Your Honours, and all those who might be following this session from elsewhere, nothing can ever justify murder, torture, and cruel treatment. It is not the fight for Kosovo's liberation, the fight for Kosovo's independence that is on trial here. We've heard the prosecutor on this issue, and let me reinforce this point. But the legitimacy of the KLA's fight, as the defense has hinted at in previous submissions, did under no circumstances ever justify torture, arbitrary detention, cruel treatment, or murder. Those fighting for independence or liberation, no matter whether in Kosovo or elsewhere, must respect the rules of war and the rules of humanity. Now let me cite here what one of the victims said to me in our conversation. The enemy was Serbia. We helped and supported in the fight against them. We invested in the fight of the KLA. We needed to fight. The enemy were not my own countrymen and women, and we are not accusing KLA values. This is the story that needs to be told and heard in this trial. The crimes committed were against fellow men and women, wrongly accused of being spies, arbitrarily detained, and brutally murdered. But the victims couldn't mourn. They could not speak out about what happened, as stigmatization continued over the years. And as I've said before, fear has kept them quiet. For Kosovo to move on, and I say this not only to your honours, but to the broader audience out there. It is important for Kosovo to grow as a beautiful country that it faces some uncomfortable truths. Torture is prohibited, whether in peacetime or in war. Equally, the right to life is the most basic human right. These provisions are preemptory norms of international law, and they are binding. The KLA was obliged to respect the right to life, to respect the prohibition of torture, as much as any other fighting force. Crimes were committed on all sides. This, however, does under no circumstances justify any violation of those prohibitions, justify any war crimes. The rules of war apply to all sides and ought to be respected. It is as simple as that. What the victims are asking for is the acknowledgement of the wrong that has been done to them. And this trial is important as it will uncover and present in this courtroom some of those uncomfortable truths. It is a sincere hope that people in Kosovo will engage with these proceedings, will listen and understand. This trial is not about the legitimacy of the fight for independence. This trial is about basic rules of humanity. A single trial far away in The Hague, though, will not overnight help to correct the unbalanced narrative of the war, lift the veil of silence, remove the stigmatization that victims of the KLA are facing. But those victims brave enough to participate in these proceedings do hope that this might be one first small step towards change. Pika, pika, mbushet pusi. Drop by drop, you fill the well. This is what one of the victims said to me in our consultation. And I think it sums up very well what drives their hopes, that this might be a contribution, a small contribution and a first step towards change. With that, let me move to the themes of justice and truth. All the victims participating here hope for justice. This became very clear. But what does justice actually mean? From the victim's perspective, they want to see those responsible held to account. They want those responsible convicted of the crimes they committed. In this trial, we focus on the accused Salih Mustafa, who chose not to be present anymore. The victims hope that he will face the consequences that the law provides for the acts he stands accused of, the acts they had to endure. They hope that all those who were responsible for the crimes committed are facing a court of law at some point. For justice to be done, though, we all need to develop an understanding for the situation in Kosovo. And when I say we, this is addressed to most persons in this courtroom who are not from Kosovo and who have neither lived nor worked there throughout our careers. This shapes our perspectives and understanding. And we need to be aware of this cultural gap that exists and that will impact our work. Let me touch us at this point on a matter that has briefly been discussed during the trial conference. Should the panel visit the crime site? There's nothing to see anymore, the Special Prosecutor's Office suggested, and similarly, the defense does not see any value in such a visit. And from a criminalistic perspective, this might be right. The immediate evidence has long disappeared. Slush as a place has changed. This was confirmed in my conversations with the participating victims. Nevertheless, as one of them said, the judges should go there to see for themselves. But why should such a visit be important? And what does it have to do with the cultural gap I mentioned? I went to Slush to see for myself. Immediately on my arrival near the village, men appeared and questioned my presence there. The driver who took me became extremely nervous and anxious. What appeared at first sight to be a very peaceful, quiet spot of land in the hills, not too far from Pristina, had a very oppressive atmosphere. A KLA memorial and symbols dominate the village to this day. And I learned a great deal during this very brief visit. Its remoteness brings home, and we've heard that by the prosecutor, what an ideal place this was as a place of torture. Who would hear the cries of those tortured or come to the victim's help? It also brought home the dominant presence of the KLA. A glimpse of Slush now will allow us to better understand what those victims who will provide testimony in court have gone through, what it must have been like back 22 years ago. Going to visit the crime site might be a challenge and might not seem significant. However, we submit that such a visit would be in the interests of justice. Rule 74 of the Rules of Procedure and Evidence equips the panel with discretion to that end, and in our view, the panel should use it. It is in the interests of justice to use these opportunities to at least try and bridge the cultural gap that inevitably exists. Now, the hope for justice is closely intertwined with the hope to finally understand what happened and uncover the truth. The truth is an empowering and healing force. We embrace it for the past, the present, and the future. With these words, UN Secretary General Antonio Guterres acknowledged the victims' rights to truth, justice, and reparations in international law. And this right to truth implies knowing the full and complete truth as to the events that transpired, their specific circumstances, and who participated. Knowing the circumstances in which violations took place, as well as the reasons for them. One of those indirect victims participating here summarized the hope for truth aptly when stating, "We want to know who did it and why." Two simple questions: who and why? As we are representing a group of victims, their experiences and hopes, of course, are not uniform. Why? This is the one question all of them share. None of them has any explanation why they were subjected to the beatings, to the violence, to the injuries they had to endure. And this will inform the way victim representation will be conducted here by us. We will exercise our right to ask questions and to uncover what happened, as this is vitally important for the victims we represent. And in this context, we have taken note of the panel's decisions on victims' procedural rights and the conduct of proceedings, and we welcome the opportunity to be able to ask those questions where appropriate to uncover the truth. Now, the accused is not present here anymore, but I do hope that the defense will convey to Mr. Mustafa what I have to say to him, that it is in his hands to help providing answers. We fully respect his right to remain silent, and we understand the difficulty of his situation. However, as Victims' Counsel, I want to emphasize how much he could contribute to providing answers. Whose hands carried out the murder of a beloved son? We call on him to live up and own his responsibility and provide such answers. We realize this appeal will remain without response now, well, and the empty chair speaks for itself. But we do not want to miss this opportunity to highlight what a courageous and honorable thing it would be to provide such answers. Uncovering the truth also contains a component of exposing the full extent of suffering. Victims participating here with dual status will have the chance to provide testimony in court, and we will notify the panel in due course if victims wish to avail themselves of the opportunity to additionally present their views directly to the panel beyond their witness statement. Your Honours, we will now address the issue of reparations, and for that I will pass the baton on to my co-counsel, Lisbeth Zechfeld.
Thank you. Thank you. Your Honours, Specialist Prosecutor, Defense Counsel, Mr. Mustafa, although you're not here. The diplomatic conference
of the Geneva Conventions of 49 emphasized it's not enough to grant rights to protected persons and to lay responsibilities on states. Protected persons must also be furnished with the support they require to obtain their rights. They would otherwise be helpless from a legal point of view in relation to the power in whose hands they are. The drafters of the Geneva Conventions were right. The position of victims of humanitarian law violations must ultimately be assessed on the basis of their right to claim reparation. This right includes their procedural capacity to go directly themselves to an organ to make such a claim. The need to create these very chambers, based outside Kosovo and staffed by non-Kosovars, was justified on the basis that it would facilitate other Kosovo domestic courts. Their work had been impeded. This court provides for witness protection and guards against corruption and political interferences. The creation of this court has been heralded as a means by which Kosovo courts provide justice for victims of past crimes. However, the law of this court still allows for referral of victims to civil litigation in other domestic courts. This is strange. It is strange in view of all those impediments that have undermined Kosovo courts. It's contradictory, and it affects the goal underlying these chambers, as well as victims' fundamental rights. Today, I'll focus on the practice of international tribunals that did refer victims to domestic courts. What has come of these referrals? What has come of this domestic practice? As we will see, this domestic practice is really sad. I'll then briefly address what to expect from civil litigation when handled in Kosovo courts other than this court. Finally, returning to these specialist chambers, I will stress the importance of compensation, apart from truth, as a form of reparation. The right to reparation and remedy is by now, fortunately, firmly established under both human rights law and humanitarian law. It's understood to be a part of customary law. However, yes, there has been by now no international criminal court or human rights court that denied victims access. But a different question is whether this should be a national or an international remedy or access. The question in which forum victims can claim their rights is unsettled. It's left to individual international courts or domestic law to decide how to give effect to the right to a remedy. The United Nations basic principles on the right to a remedy are not of much help here. I quote from these principles that they do not entail new international or domestic legal obligations, but merely identify mechanisms for the implementation of existing legal obligation under international human rights and humanitarian law. Article 13 of the European Convention stipulates that individuals shall have a national remedy. In 1993, at the creation of the ICTY, the Security Council recognized victims' rights, but did not, as we all know, provide a remedy itself. At the ICTY, the idea was that they turn to domestic courts. So there doesn't seem to exist a victim's right to a remedy before an international body. Be this as it may, at the same time, judges of the ICTY have time and again pointed out that domestic courts failed victims. In March 2011, the president of the ICTY addressed the impossibility for victims to go through national courts. He first observed, and I quote, "The tribunal cannot through the rendering of its judgment alone, bring peace and reconciliation to the region. Other remedies must complement the criminal trials if lasting peace is to be achieved, and one such remedy should be adequate reparations to the victims for their suffering. He then called for the establishment of a trust fund for victims falling under the ISTY's jurisdiction. He did so because domestic courts in the former Yugoslavia had proven no option for victims. This point was also addressed by the International Organization of Migration. At the request from the Office of the President of the ISTY, the IOM wrote a report in 1993, I say in the top of my head, no, 2013 I must say. In this report, the IOM confirmed that many, if not most victims, had remained without an effective remedy. And it stated, and I quote part of this report in full, given the importance of it. In practice, however, the IOM was told that victims in all countries of the former Yugoslavia face a multitude of frequently insurmountable barriers to obtain redress through the courts. These include the lack of financial means for court and lawyers' fees, the psychological and physical burdens that invariably long trials pose on victims, the unavailability of sufficient documentary evidence, and a continued lack of awareness amongst victims about the extent of their rights in this respect. Finally, and I continue the quote, IOM was told that obtaining a reparations award does not guarantee an effective remedy, as enforcement frequently turns out to be every bit as cumbersome as obtaining the award itself. As a result, the judicial route has not been able to offer effective access to reparations for the vast majority of victims of international crimes in the former Yugoslavia, the IOM said, and it finished saying that this was an experience that is common to many other post-conflict settings. The first ever compensation ruling in the former Yugoslavia was handed down in June 2015. June 2015. 20 years were needed for this to happen. And still, this only happened because of great support by non-governmental organizations. Among the in total 3 cases in the former Yugoslavia in which compensation has been awarded up to date, only one verdict is final. The lawyer in this case said that the convicted does not own any property, so it's going to be hard for the ordered compensation to be paid by him. In general, there's no assurance that the compensation order will ever be paid, be it in criminal or civil proceedings. And nothing is done on this issue, neither by the ISTY or the state of Bosnia-Herzegovina. Like the ISTY, also the Lebanon Tribunal refers victims to domestic courts. After the conclusion of the trial, victims can open proceedings for compensation in Lebanese civil courts using the judgment of the International Tribunal. However, the trial chamber of this court confirmed that, Lebanon has no general national compensation scheme for victims. It observed, and I quote trial chamber of the Lebanon Tribunal, under Lebanese law, there's no general national compensation scheme for victims of crimes. A victim of an offense can claim compensation for damages suffered by initiating a civil action either before the same criminal court, where the alleged perpetrators and accomplices have been prosecuted, or separately before the competent civil authority. Now, I digged into the jurisprudence of the Lebanese courts, the national courts, and I didn't find one single judgment in which compensation had been granted to a victim. In the proceedings before the Lebanese tribunal, some participating victims stated that they had received a form of compensation from the Hariri family. others received some money from an ex gratia scheme run by the Lebanese Prime Minister's office. Some had insurance against which they could claim. Some had medical expenses paid for them. But most victims were left with no compensation whatsoever. And if they received some compensation, it was wholly inadequate. The sentencing judgment of Ayash in 2020 addressed the victims' inability to pursue compensation before national courts. The legal representatives sought the establishment of a trust fund for victims of Mr. Ayash's crimes. Given the lack of a general victims' compensation scheme in Lebanon, they asked the trial chamber to recommend the creation of one. They also submitted that the trial chamber should order Mr. Ayash to pay a fine or compensation to the participating victims. The trial chamber noted, and I quote, "The evidence in the trial revealed a real inequality in how victims of Mr. Ayash's crimes were treated and compensated, and that most victims remain uncompensated." End of quote. The trial chamber found this to be contrary to the UN basic principles on the right to a remedy. It made it clear, and I quote again, the trial chamber of the Lebanon Tribunal, that it is firmly of the view that it has a moral and legal duty to the victims of crimes found to fall within the special tribunal's jurisdiction to do anything it can help them to obtain redress. End of quote. However, the trial chamber of the Lebanon Tribunal went on noting that it has no power to make formal orders against Mr. Ayash or the government of the Lebanese Republic. It therefore recommended, and I quote again, to the government of the Lebanese Republic that it establishes a national victims' compensation scheme that conforms to these United Nations principles, and the establishment of a special trust fund for victims of crimes determined within the special tribunal's jurisdiction. Looking at this practice, only one conclusion can be drawn. Referring victims to national courts to claim compensation can be no option. Domestic legislation, the institutional framework, political practice and resources determine whether victims have access to present their claims. The consequence is that redress may be available to some victims, but not to others. International criminal tribunals offer victims far better access to claim compensations. Examples are the chambers of Cambodia, the African chambers in Senegal against Habré. Though we know that their success was ultimately mixed, which was due to their own legal boundaries, at least they made serious efforts to provide victims with adequate reparation. And the best example is, of course, the ICC. It's true that the case-by-case approach of the ICC has resulted in an inconsistent jurisprudence in our view, but the most recent case, Nganda, is a landmark case on reparations for victims. And in this case, the court took a real victim-centered approach, placing emphasis on the goal of repairing the harm for victims. Now, I'll not go into the details of this practice or the other international courts that provided reparation, but my point is that given that domestic courts have generally offered no recourse, international tribunals should fully exhaust their competences to implement victims' right to reparation. Leaving victims in the hands of their domestic legal systems renders them dependent on whether the national legislation foresees a real possibility of compensation claims. And more often than not, they do not. These specialist chambers should open their doors to implement victims' right to reparation. We know that both routes are still available under the law and the rules. This court may make a reparation order itself, it may also refer victims to civil litigation in other courts in Kosovo. This court should do the first. The sad experiences of the domestic courts should make us extremely skeptical when it comes to referring victims to other domestic courts in Kosovo. The trial panel in this case has instructed an expert opinion to be provided on this matter, and we are all awaiting this report early November. But let me briefly address some of the risks already looming for victims were they to be referred by the trial panel to a national civil court in Kosovo. A crime victim compensation law exists in Kosovo. It was finally passed in 2015. 2 years later, the Crime Victim Compensation Program was launched. Under these programs, compensation from the state can be requested when the victim is unable to get restitution from the convicted defendant or from other sources. But here's the trouble. The Ministry of Justice declined to confirm whether or not the program covers victims of war crime cases. Reparations for victims is currently an unknown area in war crime trials in Kosovo, even where verdicts include jail sentences. Kosovo's domestic system has been failing victims of war crimes ever since the war ended. Another problem that presents itself concerns the protection of identity. What we've seen in Kosovo is that during criminal proceedings, victims had their identities concealed to protect them, but in civil cases, no such legal mechanisms exist. The result is that victims cannot and will not claim compensation in civil proceedings because they are at risk of exposure. Another obstacle is the tendency to negatively stereotype victims who claim compensation. We've seen this in the countries of the former Yugoslavia. Such an attitude demonstrates a lack of sufficient awareness on the side of judges of fundamental war crimes, war victims' rights. We also learned from the former Yugoslavia that even while some victims succeeded in accessing a remedy, many others have not and will not. We should learn from these experiences. Instead, these specialist chambers, this trial panel, can and should deal with victims' claims in full itself. Trials and judgment in this court are necessary. They are a painful last resort. Now, please allow me to finish with a few observations on the reparation that our clients seek in this case. First and foremost, and it has been said already today, they seek prosecution and conviction of the perpetrators of the crimes committed against them. Prosecution is, in and of itself, a part of reparation. Success of this case, in the sense that the truth is established, is crucial to our clients. But victims also have different interests of their own. One of them is that they are compensated. It's a fundamental legal principle that harm inflicted by one person on another needs redress and compensation. This principle exists in every national legal system. It exists under international law. The right to compensation is recognized by the United Nations Basic Principles, and the ICC also recognized this principle. In the latest case dealing with victims' reparations, the trial chamber observed, and I quote, "In determining the amount of the convicted person's liability, monetary liability, the primary consideration should be the extent of the harm and the costs to repair it." We have noted the trial panel's observations in this case on the importance of truth, and that establishing the truth may even be more important than compensation. We do agree on the prime relevance of truth-finding. But we also ask your panel to take the right to compensation seriously. And of course, this begins with determining the scope and extent of victims' damage and injury under Article 22, paragraph 7 of the law. And we also explicitly request the panel to do this. With the right to compensation comes the right to enforce awarded compensation. The law allows the specialist chambers to order the sale and share of forfeited property, proceeds and any assets between victims. Later in this trial, we will address the possible needs of the establishment of a trust fund, if it turns out that the accused, if convicted, lacks the means to properly compensate the victims. For now, I would like to say that we do appreciate the trial panel's questions already included on this point to the experts. Before handing over again to my colleague, let me conclude on the matter of reparation. Reparation of war victims is an imperative demand of justice. The relevance of their rights is questionable if they have no legal capacity to enforce them. As pointed out by Lord Denning, a right without a remedy is no right at all. The trial panel will have to make a decision whether it itself issues a reparation order or whether it refers victims to civil litigation in other courts. In doing so, the panel should be guided by the normative weight that the international community attaches to human rights and humanitarian law and to the principles on the right to remedy. The changes that the international legal order has undergone are reflected in the recourse to international criminal courts. Interests of justice demand that the specialist chambers resist the temptation to refer to other civil courts in Kosovo. This would be wrong, as the right to a remedy demands different. Victims will struggle to get their rights and damage recognized in Kosovo courts. It would mean that their rights would be hardly justiciable. In the interest of the law, in the interest of justice, and in the interest of our clients, we ask the trial panel to adjudicate these claims itself. Thank you. And with your permission, I'd like to hand over again to my colleague.
Reparation should be granted for all the victims participated in these proceedings. Now, no money will bring back the lost family member. No money can ever repair years of depression, of a life deprived of opportunities to work as before and live a life which allows joy and happiness. However, just to be very clear and follow on from what my co-counsel laid out here, we formally request that the trial panel include a decision on the scope and extent of damage, loss and injury according to Article 22, paragraph 7 of the law. And this request will also be filed as a formal submission in due course to the record. The victims have a right to reparations, as my co-counsel has laid out in detail. Victims testifying as witnesses will provide the opportunity for the panel to understand this damage, loss and injury. Victims' counsel will contribute to establishing this extent of the impact of the crimes on their lives through questions put to the victims where necessary. And we may additionally submit expert evidence on this matter and will notify the panel in due course so that arrangements then could be made. None of this comes, of course, as a surprise, as we have made clear in our previous submissions. And this panel is the most appropriate judicial body to award reparations. Now, Article 22, paragraph 7 provides the opportunity, of course, to limit a decision to establishing the identity of victims of any crimes within the panel's judgment. This, however, is only the case if the requested decision to establish damages would unduly prolong the criminal proceedings. We are now here at the start of this trial. With our submission today, at the very start of the trial proceedings, we are providing every opportunity for the panel to ensure that the request can be addressed throughout those proceedings here without causing any undue delay at all. Article 22.8, paragraph 8 of the law provides for the award of collective or individual reparations, and it is requested that the panel award reparations on an individual basis. This is specifically the case for those direct victims of torture whose lives have been destroyed forever. All of them deserve individual compensation for their suffering they have endured. Any collective reparations should be complementary to individual awards. The award of reparations, however, will not mean much if this cannot be enforced, and my co-counsel has made it clear that it remains extremely difficult for victims to enforce reparations where they have been awarded by courts. And we realize that this trial panel, Your Honours, won't be able to change this. Yet, this court is the forum in which justice should be delivered. Justice, however, is not just about the observance of rules and the conduct of fair proceedings. It is not only the arrangement in the courtroom that matters. The arrangements within this forum of justice are not always sufficient to deliver justice. Of course, fairness is critical, but this alone, applying the rules as they have been drafted, does not automatically mean that justice is perceived as having been served. For us, it is important that justice is realized, that we achieve a tangible outcome. Therefore, let me seize this opportunity here and address a broader audience, because our clients, those we represent, don't have any forum in which they can make any claims because they have been so silenced. Call on the government of the Kosovo, if anyone is listening from within there, the international community, to ensure that victims will be able to realize their rights to reparations. We note that a recent initiative has been launched by the government to work on a transitional justice strategy. And as we have made clear throughout our opening statement today, the current legislation and possibilities to receive war crimes reparations exclude specific groups of victims, exclude those we speak for. A trust fund for victims that would ensure that those victims of crimes addressed here before the KSC can realize their claims would be a significant step. We realize that this requires political will and support from the international community and Kosovo. To make victims' rights meaningful, this would be a most significant step. Although the call for an inclusive trust fund for victims entails a political dimension, it is very much embedded in the realization of the rights of victims participating here. Justice cannot solely be achieved by establishing a court, by observing rules that have been drawn up. Justice must also always be measured by its outcomes. The Indian philosopher Sen pointedly asked whether the analysis of justice must be so confined to getting the basic institutions and general rules right. Should we not also have to examine what emerges in society, including the kind of lives that people can actually lead? This, for me, is the measuring stick. To make a real difference, we hope that our call here today to create a collective fund does not go unheard. The victims we represent here do not have the agency or platform to speak out We have explained this at length, Your Honours, to the government of the Kosovo, to all contributing to this court. Setting up a trust fund is a missing piece in the jigsaw. It is indeed squarely within the interests of victims I have spoken to, who stressed that they do not want any individual recompense from the hands of the accused, whereas a collective fund would be most welcome. With this call, let me draw to a close and summarize our legal positions as follows. We will exercise the opportunity to ask questions where appropriate, to contribute to uncovering the truth, and to expose the full impact of the crimes. We submit that the trial panel should consider a crime site visit to gain a better understanding for the place and context in which the crimes were committed. We will, in due course, notify the panel if and how many victims may want to seize the opportunity to present their views before this panel, beyond providing witness testimony. We request that the panel include a decision on damage, loss, and injury according to Article 22, paragraph 7 of the law, and that the panel award individual reparations to participating victims according to Article 22, paragraph 8 of the law. With this, let me come to the closing aspect of this statement and emphasize once more what an important chance this trial can be to uncover the suffering of those victims that have been silenced for so long. I want to finish today with some of the hopes and wishes that the victims who I have spoken to have expressed for their future. Harmony and a peaceful family life are what I hope for. I would like to be free from fear as I am in danger. We want to create a state that really defends everyone's rights equally. And my biggest dream would be to live in peace, not to be scared. Everybody to respect the law, have equality where the law and the rule of law is respected. Thank you for your attention.
Thank you, Mrs. Pues. This concludes the opening statements of the Specialist Prosecutor and the Victims' Counsel. Before we go and have our lunch break, some remarks, very short because we are exactly at 90 minutes after we started. The panel will hear the testimony of the first two SPO witnesses between Monday 20 September 2021 and Tuesday 28 of September 2021. And in preparation for the first testimonies, I would like to inform the parties and the Victims' Counsel that in addition to the considerations made in the conduct of proceedings regarding the mode of questioning of the witnesses, after each examination of the witness, the panel might ask one or more questions to Mr. Mustafa regarding the witness statement in line with Rule 142, paragraph 2 of the rules. Mr. Mustafa will, of course, have the right to remain silent. We will now have a lunch break till 2:30. We will then continue with some disclosure issues I would like to discuss with the SPO. There is another matter, another issue which have to go in, which we will have to go for in private session. So we would do that too. And that's it for now. The hearing is adjourned.
All right.
Please be seated. Okay. I look around and I note that, oh yes, I note that the presence has changed since the break. So I see that the specialist prosecutor is not there anymore. Any other changes?
No, Your Honor.
No, no, okay. I see the same faces, no, Mr. Van Bonnet and the registry. And Mr. Van Bonnet, the defense team, there is a slight change I see there, or not?
Yes, Your Honor. Maybe Mr. Shala will be accused for the moment. Maybe he will join in later. It's, not
That's
sure.
right. It's for the record, so
Yes.
that we know who...
Yes. Mr. Pelay is present.
Okay, good. Yes. I would like to move, Madam Court Officer, into private session to discuss with the SPO a matter that cannot be shared with the public. Madam Court Officer, could you inform me when we are in private session?
We're back in open session, Your Honor.
Thank you, Madam Court Officer. Before we conclude today's hearing, the panel would like to discuss, as I already mentioned, two disclosure-related matters. The first one is the following. The panel noted that the SPO recently disclosed a number of batches of evidence, namely numbers 50 till 72. And now for the panel, when looking at the batches on legal workflow, it is not clear what each of these batches contain, whether they are a redisclosure of unredacted witness material, to which witness each item relates, whether there is also exculpatory material, and also the level of confidentiality of the items, and also if they are on the list of material as presented by the SPO in filing, the recent filing F201. And in order for us to obtain some kind of information, like I just mentioned, we need to open the items one by one. And it makes it difficult to orienteer through these batches. And from our side, we would really appreciate if the SPO could file something like a disclosure note, even if it would be in the form of a table, outlining the information I just mentioned, as well as the ERN number for the batches 50 till 72, and any future batches, because that would help us, and I can imagine the other party and participant to go through the batches a little bit more quickly instead of opening it one by one. So would that be possible, Mr. Prosecutor, and in the affirmative, in what time frame? You have the floor.
Your Honours, very few words of the explanation in this regard. Indeed, from batch number 50, we have started the disclosure of the material that had been already previously disclosed. This time, we are disclosing this material in an unredacted format to the defense, for the defense to be able to better prepare for the cross-examination of the incoming witnesses, especially the first ones, and for your Honours to have everything again in front of you when we start interviewing witnesses from next week onwards. If there is any unclarity as to the content of the package, and we understand that there might be, and if there is any unclarity, I hereby solemnly apologize for it. We will indeed prepare a comprehensive list indicating the batches and what the batch precisely contains, and we'll provide it to your Honours also by Friday this week, not later than that.
Okay.
And then we'll have clarity, I believe.
Okay. Mr. Prosecutor, thank you. In this case, I will issue then an oral order on the matter to make it clear what would be in the disclosure note. So the order is as follows. I hereby order the SPO to file disclosure notes for evidentiary batches 50 till 72 and for any future batch, including the following information. That would be the ERN number for each item disclosed in the batches, a description of the content of each batch, including whether they are redisclosure of lesser redacted or unredacted material, and in relation to which witness it is applicable, if there are on the list in Annex 1 of Filing 201, the rule or rules under which they are disclosed, and the level of confidentiality of the items. And this concludes the oral order. Yeah? Okay. And then the second issue, the panel noted that some of the ERN numbers of the items shown to the witness during the SPO interviews cannot be found on legal workflow. And we have the impression because they were renumbered. And I have some examples. For example, I could mention witness 3593. And I see you already nodding, but can you confirm this or give an ulterior explanation?
Your Honours, indeed, when we were presenting some exhibits to the witnesses during the pretrial proceedings, Then we were giving all the old exhibits, are the old ERN numbers, new ERN numbers. The batches from 50 to 72 also intend to clarify this issue because they are released, if necessary, of course, under the proper numbers that should be there and that will be used during the examination of the witnesses. So I think that with the provision of, as Your Honor named the disclosure note, everything should be clear because the numbers will be there, the correct ones, so there will be no confusion on the part of anybody. And again, if there was any conclusion, we again apologize for it. It's easy for us because we conduct those proceedings, we assign those numbers. It might not be easy for people who are not a part of these proceedings in the pretrial phase.
Yes. In addition, would it be possible to receive a conversion table? Because with the old number and the new exhibit number? Because yeah, if we have a table, then when we work through the witness statement, we just have to look what the new number is, and then we can find it in legal workflow.
Yes, Your Honor, of course, we will provide such a table just to avoid confusion, because indeed, sometimes if you read the pretrial statements, the old number is quoted later on. For example, a photograph presented to the witness is then relabeled, another number is assigned, and then which number is it really when we use a certain document, photograph later on. So we understand we will also provide this table.
Okay. Now, then I will make another oral order in order to assure us of that. Now, I hereby order the SPO to file a conversion table indicating the old reference numbers and the current ERN number of all items shown to the witness whom the SPO intends to call to testify. And this concludes the oral order. Okay, thank you. Now, at this point, I am looking to the parties and to the Victims' Council to see if they have any other matter they want to raise today.
Your Honor, there's no other submissions from the prosecution.
Okay, thank you.
Thank you. Nothing from our side.
Okay. Mr. Van Bonnet?
Your Honor, I noticed the SPO filed an application for admission of material through a bar table motion, and I was wondering what the status of that is now. Is there any ruling on it, or is that it was the document?
I know exactly
the
what
13th,
filing you
yes,
are referring to.
I would just like to have some clarity about the status of that document right now, honestly. Other than that it is an application for admission of material.
As far as necessary, as provided for in our decision on the admissibility of evidence, we will take a positive ruling. For example, if there is an Article 37 request, and on others we won't take any ruling. But you can, of course, as provided for in the decision on admissibility, you can, of course, provide with observations. And we are still in that period that you can provide with that.
Right.
So there will be, if needed, an explicit ruling of our side, depending what is provided for in the law and the rules, and the decision, or there will be no ruling. And that's also explained in our decision on the conduct. Not the conduct, on the admissibility. Does that clarify your doubts?
By the latest, when would you like to have the observations from the defense, if any?
We have, if I'm right, we have arranged for 24 September, filing 169, paragraph 43 till 45, and paragraph 35 till 36. Shall I repeat that for you? Yes, I can understand. The responses are due on the 24th of September, filing 169, paragraph 43 till 45, and also paragraph 35 and 36. And it's called a bar table motion in the filing. The panel will not call it a bar table motion, a bar table, but a list with material. But okay. Does that clarify? Is that an answer to your
Yes,
question?
thank you very much, Your Honor.
Okay. Good. So no other matters to raise, and this concludes today's hearing. I thank the parties and the Victims' Council and the team and the registry for their attendance. I also wish to thank the interpreters and the stenographer back there and the audiovisual technicians and the security personnel and the court officer for their assistance today. The hearing is adjourned.
All right.